Well, thank you for coming on a Friday afternoon. It is a beautiful, beautiful day. We were joking this morning during the tornado drill that John was literally flying to the eye of the storm to come be with you today. It's really, really a great pleasure to introduce Mr. John Bellinger III, the State Department legal advisor to the Secretary of State. This is the 5th Charney lecture. Mrs. Sharon Charney is here in the second row. This is the 5th Charney lecture, and I have to tell you that we tremendously appreciate the generous support of the Charney family and the generosity that allows this lecture series to take place. It's a really important part of our curriculum, and we thank you. We thank you for your support of the school, and we thank you for your example, and we thank you for what you've done and who you are. For those of you who weren't fortunate enough to know Professor Charney, let me tell you just a little bit. He served this law school for 30-plus years. And that in and of itself is an amazing contribution. You could spend all day long finding old students and wonderful contributions to this environment. But more importantly, he didn't just serve this school. He served our country, he served humanity, he served the needs of the law in a variety of ways. We could spend a long time. The soundbite is that he was really, truly one of the preeminent legal scholars of his era in international law. I'm going to say that again because it's true. He really, truly was one of the preeminent scholars in his field in international law. He left a lasting influence on this school. Let me give you just one example. And it's appropriate that this Charney lecture this year coincides with the American Society of International Law meetings in Washington. John Bellinger was on a panel yesterday, as was I, in Washington. All the major international lawyers gather in Washington. And as you walk in the door, it's a veritable cornucopia of booksellers. I mean, it's sort of like a feeding frenzy. And I admit I'm weak-willed, right? So I go in there and I spend more money and buy more books than I really should, but it's okay because it's ASIL, right? What goes on at ASIL stays at ASIL, and you can buy books. So I buy this wonderful, wonderful book on terrorism for our Vanderbilt in Venice program this summer. And of course, not surprising because you know where I'm going. When you look in the back about the sources and the methods, there's John Charney, listed as one of the primary contributors, drawing on his scholarship, drawing on his expertise. The key about this lecture series, and I've tried to think about the thematic theme. You know, we've had different speakers on different topics, so there's no topical theme. If there is a theme, it's this. It's that every person who's come to this law school to speak in this lecture series endowed by your husband and in his honor has had two notable characteristics. They've been people of great, great, great character and enormous personal competence. And that's really the theme. To blend character and competence and professionalism with a kind of a personality and a dedication to the law, that's really the theme that ties this together, and if I said nothing else about this distinguished visitor, that's what you should remember. Let me tell you a little bit about him. It's especially fitting that John is here to be with us. Since April the 8th of 2005, he has joined the long line of distinguished servants who have served as the legal advisor to the Secretary of State. In that capacity, he's the principal legal advisor both to the Secretary of State but also to consulates and missions all around the world. And we used to joke that there is no night switch, right? There's a legal problem all around the world. Somewhere it's midday, and somewhere they're in the height of their legal problems, and somewhere, almost always around the clock, they're counting on him and his great team of lawyers to give them the right answer. They do it 24 hours a day, 7 days a week, with tremendous dedication and courage. It takes a lot of legal courage, it takes a lot of moral courage to do that well, and this is the embodiment of that. John graduated from Harvard Law School with academic honors. Not an easy feat in and of itself. He also has degrees from Princeton's Woodrow Wilson School and from my own alma mater, the University of Virginia. I could give you a long list of his government service. Truly a dedicated government servant. He served for the Senate Select Committee on Intelligence for a period. He served as the senior advisor or special assistant to the Director of Central Intelligence for a period. He served in our own Justice Department as the National Security Affairs Counsel, General Counsel in other capacities. And I could spend an enormous amount of time telling you detail by detail by detail of the legal contributions he's made, the places that his fingerprints are on policy and law. I don't want to do that because, in fact, What you're about to hear is a very important and a very significant speech. It's significant in its own right because it's one of the Charney lectures. But it's also a very important statement of U.S. policy in a very important and developing field of litigation. But John made a special point to ask me that the question and answer session is not just limited to human rights litigation in U.S. courts. He really is here to answer questions on a variety of other topics, which he does all around the world all the time. Apart from the depth of professional accomplishment, and this is very similar to Professor Charney, I will tell you that with certainty, he's a man that people personally admire. There's a charisma, there's a wry humor. I will tell you with absolute certainty, because I know them, they're friends of mine, his subordinates love to work for this man, which is a truism. That, I think, is in the finest traditions of Professor John Charney. John, we're so thrilled to have you here. Please join me in welcoming Mr. John Bellinger.
Well, thank you very much, Mike. You embarrassed me. It's a privilege for me to be here. I have never been to Vanderbilt. I was just saying I do not think I have ever been to Tennessee. You have arranged, while the tornadoes were here before I got here, you've arranged for a lovely day for me. I've already been out and walked around your quadrangle, and I'm really just delighted to be here. So I am keenly aware that it is now a beautiful Friday afternoon, so I am really honored that for the students that have come out. And for Mrs. Charney, it's wonderful to meet you. I was not privileged enough to know your husband, but as I was saying to you, he is extremely well known to the lawyers in my office. I manage a law office of about 180 lawyers who do pure public international law, fascinating work in negotiating treaties and representing the United States around the world. And one of the most significant areas is in areas relating to the oceans and the law of the sea, in which Professor Charney was really one of the world's experts. When I left yesterday, or was getting ready to leave yesterday, my lawyers brought to me Professor Charney's book on Maritime Boundaries, which is a book about this big, and it has little yellow stickies all up and down it as where my lawyers rely on his work. He was on the original law of the sea delegation on this important treaty. And I will mention, be happy to take questions on this. I actually talk fairly regularly about the law of the sea treaty. We are making a really big push last year and this year to get the Senate to approve this important treaty. Sadly, it is one of these examples where we are pushing for something important in the international law area, but has become controversial in the Senate because of myths left from 10, 20 years ago that the treaty would somehow not be in our interest. And really, because of the work done by Professor Charney and others, it is very much in our national security, our economic and business interest, and really a fascinating treaty. So thank you very much for endowing this lecture series. I hope I can live up to the things that Mike has said. And I'm particularly glad to have the JAG lawyers from Fort Campbell here. I've worked very closely with many of their fellows in Washington. The work between the State Department and the military lawyers is extremely important. And of course, Professor Newton is a great example of that. We've worked very, very closely over the last 7 years. He was a great find for Vanderbilt, and I am really privileged to be down here. Now, my talk today is about enforcing human rights in U.S. courts and abroad. As you may know, U.S. foreign policy under every administration, Republican or Democrat, involves promoting respect for human rights around the world. Most of you probably know that the State Department spends a great deal of time and effort abroad persuading foreign governments to change their human rights behavior and administering programs to advance the cause of human rights. What many of you may not be aware of, indeed I was not aware of until I became a legal advisor, is that we are now quite frequently occupied domestically with suits brought by foreign plaintiffs in U.S. courts, often arising from conduct that occurred in other countries and has no significant connection to the United States, that may not be consistent with our governmental policies for promoting human rights. And that's where I'd like to focus my remarks today, in particular on something called the Alien Tort Statute, or ATS, which is a nearly 220-year-old statute that has been interpreted to allow foreign plaintiffs to bring suit in U.S. courts for violations of international law. Now, let me just start by seeing who knows something about the Alien Tort Statute. So about half. Good. You all will know that the Alien Tort Statute was the subject of a very important Supreme Court decision in 2004, which was called Sosa versus Alvarez-Machain, which outlined the limited reach of the Alien Tort Statute. Still, ATS litigation continues to present complications for U.S. foreign policy and our efforts to promote human rights around the world. Let me make several observations regarding the ATS at the outset. The first is that ATS litigation continues largely unabated, despite the Supreme Court's effort in Sosa to rein it in. Second, the ATS has given rise to friction, sometimes considerable, in our relations with foreign governments, who understandably object to their officials or their domestic corporations being subjected to U.S. jurisdiction for activities taking place in foreign countries and having nothing to do with the United States. Third, the development of the scope of the Alien Tort Statute has largely been left to litigants and the courts without formal involvement from Congress, and largely contrary to the views of the executive branch. This has been a problem, not least because many recent ATS suits have tended to implicate important aspects of U.S. foreign policy. In the end, there are good reasons for limits on the scope of ATS litigation, through courts exercising restraint or, if necessary, through congressional legislation. We need to ensure that the Alien Tort Statute does not complicate international efforts by the political branches to promote human rights abroad, a cause to which the United States is deeply committed. But first, let me give you some background on the statute. Many of you are familiar with the statute, which is also referred to as the Alien Tort Claims Act, and you may already know that this is one instance where reading the text of the statute doesn't get you very far. In its entirety, the whole thing says, quote, "The district courts shall have original jurisdiction of any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States." The ATS was included by the first Congress in the Judiciary Act of 1789, but in its first 190 years, the statute provided jurisdiction in only 2 cases. And why it was enacted was something of a mystery. This led Judge Friendly in a famous ATS case to call it a legal Lohengrin, because no one seems to know whence it came. What little we do know about the ATS's origins suggests that its principal motivation was to provide redress for offenses committed by U.S. persons against foreign officials in the United States. In the pre-constitutional period, there were concerns that foreigners would not have adequate redress in state courts for wrongs committed against them in violation of international law. And under the law of international responsibility at the time, the U.S. would then be held accountable internationally for the failure to provide such redress. The jurisdictional scope of Article 3 of the Constitution and then the enactment of the Alien Tort Statute by our first Congress addressed this issue by providing jurisdiction for foreigners to seek remedies in federal court. Now, after that 190 years of really not doing very much, the modern origins of the Alien Tort Statute date to the Second Circuit's 1980 decision in a famous case called Filartica, which permitted an alien tort statute by 2 Paraguayans living in the United States against a former Paraguayan government official who was also living in the United States at the time for the torture and killing of a family member back in Paraguay. The court held that torture is a violation of the law of nations and that under the Alien Tort Statute, U.S. courts could decide a torture claim arising in a foreign country. The decision, in effect, sanctioned the use of this old Alien Tort Statute for international human rights litigation, and from there, ATS cases in the federal courts grew substantially. After this case, Florida, federal courts heard myriad suits alleging human rights abuses by individuals, including notably a suit brought against the leader of the Bosnian Serb insurgents by the citizens of Bosnia and Herzegovina, and a suit against former Philippine President Ferdinand Marcos by Philippine nationals. In the 1980s, most ATS cases tended to involve circumstances like those in this Florida case, suits by foreign nationals against officials of their own government for conduct that occurred in their foreign country. But by the 1990s, the focus of ATS litigation expanded, with plaintiffs bringing more and more suits against private actors, primarily corporations, for, among other things, aiding and abetting alleged human rights abuses perpetrated by foreign governments. In all, more than 100 ATS suits have been filed since the Florida decision in 1980. And against this background, the Supreme Court, for the first time, considered the Alien Tort Statute in its modern incarnation in the 2004 case of Sosa versus Alvarez-Machain. Now, in Sosa, a Mexican plaintiff alleged that the defendant, who was also a Mexican national, had acted at the direction of our Drug Enforcement Administration to help abduct him in Mexico and then bring him back to the United States. The plaintiff was subsequently prosecuted by U.S. authorities, and he was acquitted. He then contended that his forcible abduction in Mexico by this fellow Mexican amounted to an arbitrary detention in violation of customary international law. But the Supreme Court ruled that the Alien Tort Statute is only a jurisdictional statute and does not by itself create a cause of action. But the court also reasoned that the first Congress understood that the district courts would recognize private causes of action for certain torts in violation of the law of nations. Justice Souter, who wrote the opinion for the court, identified 3 18th century causes of action that would be actionable under the Alien Tort Statute. Offenses against ambassadors, violations of safe conduct, that is, official permission for a foreigner to travel freely through the United States, which used to at least happen in the old days. They don't travel quite so freely anymore. And the third was piracy. The court also did not foreclose certain additional suits for violations of international law, provided, among other limitations, that the claim, and this is a quote from the case, rests on a norm of international character accepted by the civilized world and defined with a specificity comparable to the features of these original 3 offenses. Applying this limitation, the court rejected Sosa's specific claim that international law prohibited arbitrary detention, essentially saying it wasn't an offense against ambassadors, it wasn't piracy, it wasn't violation of safe conduct, and it wasn't close enough to those kinds of cases to be actionable. Now, Justice Scalia, in a concurring opinion, went farther, and he would have held that the Alien Tort Statute is jurisdictional only and that it does not authorize present-day federal courts to create any new causes of action. That task would necessarily fall to Congress. So the court essentially accepted the narrow jurisdictional interpretation of the Alien Tort Statute advocated by the executive branch, but it did hold that the Alien Tort Statute authorized federal courts to recognize certain new causes of action. Significantly, however, the court identified a number of factors that counseled special judicial caution and a restrained conception of the discretion a federal court should exercise in considering a new cause of action. Among other things, the court recognized, quote, the potential implications for the foreign relations of the United States, that courts should make courts particularly wary of impinging on the discretion of the legislative and executive branches in managing foreign affairs. Accordingly, the court stressed that devising new federal common law causes of action based on international law, quote, should be undertaken, if at all, with great caution. Justice Souter's opinion summed up the situation. The door for ATS litigation was, quote, still ajar, but subject to vigilant doorkeeping. So that's where things were left in 2004. And that was just before I became the legal advisor at the State Department. Now, notwithstanding the court's directive for restraint, almost 4 years later, the litigation has showed no signs of slowing down. Plaintiffs continue to push against the door that the court left ajar, arguing for expansive applications of customary international law. Among the suits that courts have heard are a suit against an American company for selling to Israel bulldozers under a U.S. military assistance program that were eventually used to demolish Palestinian homes. So just to follow that, the plaintiffs in this case, who were Palestinians, sued the Caterpillar company for selling bulldozers to Israel that Israel ultimately used in bulldozing Palestinian homes, claiming that that was a tort that they should be liable for here in our U.S. courts. Similarly, a suit against U.S. chemical companies that manufactured Agent Orange used by the U.S. military as a defoliant during the Vietnam War. A suit that I've been dealing with recently against some high-level government officials in the United Arab Emirates, alleging that they were involved in employing underage camel jockeys to do camel races. I actually just have to say, in that case, I had one of the lawyers in my office go out to the United Arab Emirates to observe camel races to see exactly what was going on. See, I tell you, you got to join the legal advisor's office. You get to do interesting work. And another example, a suit against a Canadian energy company for aiding and abetting human rights abuses by investing in Sudan. The Second and Ninth Circuits, in particular, have proceeded just as they had before, as if Sosa had not happened. And in fact, one Sosa federal court has frankly conceived of its role as that of a, quote, quasi-international tribunal dispensing an international law that supersedes and supplies the deficiencies of national constitutions and laws. This continued litigation under the Alien Tort Statute reflects fundamental problems with how lower courts have approached these suits. These problems center on 5 key issues. First, whether the Alien Tort Statute even applies extraterritorially. That is, can a U.S. court properly apply U.S. federal law under the Alien Tort Statute to conduct that occurs entirely in another country? Second, even if such a cause of action could properly be recognized, whether exhaustion of adequate and available local remedies in that foreign country should be a prerequisite to bringing an Alien Tort Statute suit. Third, whether corporations or other private entities may be held liable under the Alien Tort Statute for aiding and abetting human rights abuses that are actually perpetrated by the foreign governments. A fourth issue is how to apply Sosa's requirement that an international law norm be sufficiently accepted and specific. And then fifth, in what circumstances should courts dismiss suits based on what the Supreme Court said in Sosa should be, quote, case-specific deference to the political branches. Now, right now there is a case pending in the petition stage before the Supreme Court called American Isuzu Motors, and it's also known as the apartheid case, which exemplifies both some lower courts' resolution of these questions and their approach to the Alien Tort Statute after Sosa. This case, which is a very significant one, particularly if the Supreme Court takes it, was brought by former victims of apartheid in South Africa against more than 36 private companies, mostly U.S. and European companies. Basically, it's all sort of Fortune 50 companies for allegedly aiding and abetting human rights abuses that were committed by the former apartheid regime. And in essence, the case seeks to hold these companies responsible for doing business in South Africa during the apartheid era. In the district court, the post-apartheid government of South Africa filed a statement of interest in our courts objecting to the suit and urging that it be dismissed. The filing stated that the litigation threatened investment in South Africa and interfered with South Africa's resolution of the legacy of apartheid, which was, quote from their brief, informed by principles of reconciliation, reconstruction, reparation, and goodwill. When the case was still being litigated in the district court, the Supreme Court in Sosa took the extraordinary step of singling it out in a footnote in the Sosa case as possibly appropriate for dismissal on case-specific deference to the political branches, noting that the South African government had filed a brief objecting to the case. The district court heeded these cautions, and it did dismiss the case on the ground that aiding and abetting claims are not actionable under the Alien Tort Statute. But the interesting thing is that the Second Circuit then reversed, relying in part on the absence of any express restriction in the Alien Tort Statute on aiding and abetting liability. And this, despite the Supreme Court's probably unique admonition in Sosa that specifically mentioned this case as one where the courts should exercise restraint and look to positive legislative guidance. So in February of this year, the United States filed an amicus brief requesting that the Supreme Court grant cert in the case to consider whether the Alien Tort Statute allows suits for aiding and abetting and allows U.S. courts to apply U.S. federal common law under the Alien Tort Statute to conduct occurring in a foreign state. If the Supreme Court grants review, then this case could be heard as early as this fall. So it's really worth having a look at. Now, the U.S. government's brief urging certiorari in the apartheid litigation is one of the many statements of interest and amicus briefs that we've filed in Post-Sosa in those ATS suits that implicate significant U.S. foreign policy interests. Since Sosa, we've made many such filings in about a dozen cases. Given the nature of the underlying allegations in certain cases, the decision whether to file essentially against the human rights plaintiffs is a difficult decision for us, particularly at the State Department. Our usual practice then in these cases has been to make arguments for general legal principles concerning ATS litigation and to avoid delving into the underlying merits of any particular case. We've typically argued, as we have in the apartheid case, for limiting ATS litigation by resolving legal issues in light of Sosa. So our arguments have included the issues of extraterritoriality, aiding and abetting, and exhaustion of local remedies. For example, we argued in a Ninth Circuit case that a cause of action does not lie under the Alien Tort Statute for a suit against a British mining company concerning conduct that occurred in Papua New Guinea, and that in any event, plaintiffs should seek their remedy first in Papua New Guinea, not in a federal court in California. The executive has sought to have courts dismiss one case, the suit involving the bulldozers used by the Israelis, based on the case-specific deference to the political branches, essentially that they would be second-guessing the U.S. government's decision to allow the bulldozers to be provided to Israel. Although the bulldozer case was dismissed, these arguments have not always won traction in our lower courts, and they remain in play in a number of cases, and ultimately their validity will likely have to be determined by the Supreme Court. Now let me turn to some of the issues that are actually raised by human rights litigation under the Alien Tort Statute. To start, it's been argued that Alien Tort Statute litigation holds out the possibility of certain benefits. Let me mention a couple of them. First is that alien tort suits can promote accountability and provide a public voice to the victims of what are truly terrible human rights abuses around the world when no other forum in their country is available, and that allowing claims of human rights abuses to be heard in court in the United States helps to recognize the dignity of the victims. Second is that alien tort statute litigation may help to raise public and political awareness of human rights abuses that might not gain attention otherwise, which it is said might have the effect of spurring political action to redress ongoing abuses, prevent future abuses, or devise appropriate standards of conduct for corporations. So essentially, the litigation is a way to pressure companies or governments into a particular result. And third, ATS litigation might advance U.S. participation in the development of customary international law. Now, apart from the fact that these are not actually legal arguments under the Alien Tort Statute and were not the reasons for the enactment of the Alien Tort Statute, these benefits also may not be as significant as they might first seem. Alien tort cases might not always be driven by a single desire to see justice done. Like all private civil litigation, they might sometimes be motivated by other considerations, like money or politics. Moreover, litigating issues in U.S. courts does not generally promote the development of effective remedial mechanisms in the foreign country concerned. The benefits of having U.S. courts engage in the development of international law are also not altogether clear, because much ATS litigation is focused on defining U.S. domestic law and its proper reach. And properly so. The Supreme Court held in Sosa that the law to be applied by our courts under the Alien Tort Statute is U.S. federal common law. That law governs, for example, the extraterritorial application of the ATS, and also in large part aiding and abetting liability and exhaustion of local remedies. When courts do consider customary international law, there is also a risk that their interpretations could be in tension with those advanced internationally by the executive branch. But still, an assessment of the Alien Tort Statute as a matter of policy needs to consider these issues. But there are also substantial costs to Alien Tort Statute litigation. The important ones are not financial. Alien Tort Statutes can be expensive to contest, but so far Alien Tort Statute litigation has not produced large judgments that can realistically be executed. Indeed, that is one of the weaknesses. It does not provide any effective relief in the vast majority of cases. The real costs, however, fall into two basic categories that I will call diplomatic costs and democratic costs. First, the diplomatic costs. Here, I can assure you, from the point of view of the State Department, that foreign governments do not see the Alien Tort Statute as an instance of the United States constructively engaging in international law. In fact, quite the opposite. We are regarded as something of a rogue actor by allowing these suits. We are perceived accurately as having established, in effect, an international civil court, a court with jurisdiction to decide cases brought by foreigners arising anywhere in the world by the light only of its own divination of universal law and through the extraterritorial application of U.S. law concerning rights and remedies. By itself, this can be grating enough to foreign governments. But it's especially so when taken together with both the fact that the U.S. often argues vigorously against the assertion by foreign courts of universal jurisdiction to hear cases involving U.S. officials, and the fact that the U.S. has declined to join the International Criminal Court because of concerns about that tribunal's jurisdiction. In letters to the State Department or in amicus filings in federal courts, foreign governments consistently argue that the assertion of U.S. court jurisdiction over cases that have little connection to the United States is inconsistent with customary international law principles and interferes with their national sovereignty. Canada, for example, internationally a strong promoter of human rights and accountability for human rights violations, strongly objected to a case in the Second Circuit against a Canadian energy company for allegedly aiding and abetting human rights abuses in Sudan. Britain and Australia, also leading human rights advocates, have similarly argued that the scope of Alien Tort Statute jurisdiction is inconsistent with principles of international law. And when you consider the Sudan case or the apartheid litigation from other countries' perspective, which is a good thing to do generally in international law and relations, there's considerable force to these criticisms. Imagine, for example, what the U.S. reaction would be if, say, a Swiss court sought to adjudicate claims brought against U.S. officials or businesses for Jim Crow-era racial restrictions, or since without a statute of limitations, alien tort statute suits can reach far into the past, even for slavery. Imagine if U.S. officials were being sued in a Swiss court for slavery that had happened 150 years ago. As much as we might denounce these past injustices, most of us would probably take offense at the notion that a Swiss court could hear such a suit and decide it based on the court's own articulation of international law. The United States, after all, has come to terms with and sought to remedy the effects of slavery and Jim Crow laws through domestic measures under acts of Congress and state laws resting on a strong moral consensus of our people and according to the principles, procedures, and norms of our own legal system. But from the South African perspective, the apartheid case must look very similar, and it is no wonder that the South African government has asked that the case be dismissed. Serious diplomatic costs also attend Florida-type litigation against foreign officials. For example, a series of ATS suits against Chinese officials by Chinese Falun Gong members is an issue of considerable importance to the Chinese government. In these suits, plaintiffs have served Chinese officials while they were traveling in the United States on official diplomatic business, which is the basis for the court's personal jurisdiction. The diplomatic friction caused by these cases runs directly contrary to one of the reasons for enacting the ATS in the first place, to prevent harassment of foreign officials in the United States and prevent international incidents. And it strikes other countries as hypocritical to entertain